This is the opportunity of a lifetime for people that have businesses and brands out there. Email us right now at advertise at hiphopun.com and you will get an opportunity to put your brand right in front of each video that we do. And let me tell you, the prices are crazy affordable. You definitely can afford it. Email us right now, advertise at hiphop.
My name is Anthony Williams. I'm an attorney. I've been practicing actually in my field for over approximately 17 years. I graduated from Tuskegee University, all HBCUs, went to Texas Southern University, Thurgood Marshall School of Law as well. And yeah, I wanted to volunteer myself to, you guys' platform just to share whatever light I can on any type of legal questions that you have. So I'm here.
Dope. Okay.
Let's jump into first because we talked about this earlier, and I'm not gonna hit you a new curveball. I promise. You know what I'm saying? The ALFORD plea.
That's fine. You can hit me with it. I'm ready for them.
All right, cool.
Nice.
Let's talk about the ALFORD plea. And I read the statement from Gunna's attorney, Steve Saddle, where he pretty much said that he was taking this plea, and this plea would not be able to be used at any point in this trial or against any other current witnesses. Could you kind of just elaborate on the ALFORD plea in that as well?
Right. Yeah. So from I think the first thing to kind of it's almost like you have to do with your analysis, you got to do like a bifurcation, right? You got to kind of separate when we talking about a plea versus when we talking about somebody making an admission, right? You can always get a guilty plea without somebody making admissions to the facts, right? So according to the ALFORD plea, based on our conversation earlier and me kind of doing a light research specifically of that term, since that's the term that was coined. My understanding of that is essentially that is the person that is pleading, making the plea. That person specifically is saying, although I might not be guilty, the state or the prosecutor, whoever they have enough facts to convict me. Therefore, I'll plead. Right. That's saying one thing as it relates to themselves, but the fact of whether you attest to or whether you are agreeing to certain facts, that's something different. For example, a person can, plead guilty all day long to a shooting, to a DUI, to whatever the case may be. But when you open yourself up to be sworn in, you raise your hand, you get sworn in, and you say, I swear that, oh God, did A, B, C, and D. At that point, at the point when you're swearing yourself in, the only purpose of that is for the prosecutor or the state's attorney to tie you into those facts.
Wow.
And usually what happens is when they tie a person into those facts, the purpose of that is to kind of catch the other co-defendant. So essentially what will happen is you, at a previous date, let's just say in that particular case we're talking about now, is not in a trial posture. Let's just say it goes into a trial posture in 2023, right? So at the point when it goes to trial, they can come back and get the person that got sworn into the facts and say, isn't it true that in December of 2022, on what was yesterday's date, the 15th, you swore that A, you also swore that B, you also swore that C, so that's pretty much how the state or the prosecutor use that tool. Now, that's not to say that at that point, whomever it is that swore to the facts can't, recant and say, oh, I was just lying just to, do whatever. But, then that'll be an issue for the trier of fact, whether the judge or the jury would believe that you lied in order to get released, get a deal, or get whatever you got. You know what I mean? In order to get out. But I think the real issue is a plea is different than being sworn to the facts. And at the point where, and I have had defendants all the time that have pled guilty, but not necessarily sworn to the facts. You know, and when a person does plead guilty and they ask to get sworn to the facts, I have the longer conversation, you know, where you having this longer conversation like, hey, you know what this means, right? You know they're gonna mess around and call you back and you're gonna have to testify against your buddy, you know. Right.
I want to read something. This came out a few hours ago. This is out of Rolling Stone. The headline is "No Gunna will not testify against YSL," and it reads, "Gunna will not be called to testify against any defendants in the indictment against Atlanta-based YSL. Gunna was released from Fulton County Jail Wednesday on the ALFORD Plea Agreement and was sentenced to 5 years. We just spoke about that. They also say it is understood that the state is not going to call him as a witness. The source, who wished to remain anonymous due to the ongoing nature of this YSL case, explains that's why the plea agreement is written exactly the way it is, because the whole idea was the state wasn't going to call him and they didn't want the defense to call him either. If you look at what was said in court, that stops the defense from calling him, but also indicates that he's never going to testify for the state. The source contends that the aim of the plea is to neutralize him and keep him out of the game. How are we to interpret that?
You know, and that comes with I think at that point you have the nature of the agreement, right? We will probably never be privy to the nature of the agreement between the parties, right? So we won't necessarily per se have the actual content of what was agreed to between the parties. But what we do know, and, you know, and based on my experience, what we do know is we have, you know, an accused, a defendant, who accepted a plea where he admitted culpability, not only for himself, but for a co-defendant. And I believe he admitted at some point where he didn't have ownership of certain contents that was in the vehicle versus, you know, whether or not the other person did. So, you know, I can't per se, of course, talk to the contents of, you know, what was actually in the plea agreement. But I would say this, you know, under the, you know, the theory or the old antics, where there's smoke, there's fire, you know, or if it looks like a duck and it quack like a duck, then what is it?
It's a duck. Right?
Well, based on my experience with prosecutors and the reasoning for them requiring a person to make certain admissions on the record and get sworn to the facts, you can say they could use it to tie a person in. Number one, to tie the person in to that version, right? So now, if they try to deviate, if they're called later on as a witness, if they try to deviate, you know, you can say, okay, well, look, this day you swore to tell the truth. You did tell the truth. You're being honest, and this is what you said. So not only do you have that, but, you know, you have you're tying them to the record just in case you decide to call them. So I could see where, you know, a person would say to neutralize, you know, them at a later date. So now he can't say you know, whatever was not a gang, or, you know, you weren't in a car on these particular days. I can see where you can say you can try to neutralize them to that point, but based on history and my experience, I would believe that they tied them into the facts specifically to, you know, tie his testimony in case they called him on a later date, so that he can't deviate from those facts and that they could use him against his co-defendant.
Gotcha.
Right. And one part.
See, but that's the hard thing about it, is one of those things where we kind of just gotta wait for the other shoe to drop, right?
Mhm.
And we gotta wait for the trial in order to see, because let's just say under some circumstances, like even though he swore to the facts that he swore to, and although he swore to some facts which you and I may perceive to be damning, right? We like, I can't believe he did Young Thug like that. We
Mhm.
may look at it like that, but it really wasn't like per se crucial. You know what I mean? Like, he didn't say that whatever was in the car belonged to him. He didn't say the gun belonged to him. He didn't per se say, you know what I mean? So it's still wiggle room there for the attorney to potentially say that just because it was Gunna or whatever denied it does not mean that it's per se my clients. So it's still room for him to for the defense, I think, to work at that point.
Right. Well, I think one part that we left out also, somebody dropped it in the chat as well. He did admit to seeing criminality from them as well. How does that shake things up?
Right. See, and again, you're gonna have to everything. Most criminal offenses, right, have like what they call like a mens rea attached to it, right? And when they say mens rea, they mean like that mind state. You knowingly did A, B, C, D, E, F, G, whatever it is. Like you had that proper mind state to commit the offense. So even though this one person that swore to the facts, he admitted to or he swore to certain things, that to me that still doesn't prove the mens rea, the mind state of the principal person, Thugger, in this particular case, right? It still
Right.
don't prove that Thugger knew what was going on. Like, you have to be able to prove that. So oftentimes, without saying too much, oftentimes we are, as being with defense counsel, we kind of are lucky that the prosecutor maybe stopped short a question or two. You kind of look like, thank God he didn't ask, that other thing, that where he could have tied it in a neat bow. You know what I mean? He kind of stopped a question or two, before, where he should have did that would have really like damned our, client off. So I think that although there was a certain admission, the defense probably still will have some room to work.
I want to ask you, what do you think overall about Young Thug's current situation? But before I do, how does Gunna's statements or the question or the answers to the questions that were asked to him before his release, how does that affect Young Thug's current situation?
You know what though? I think it never can be good, right? I don't think that it can be good regardless of what you look. A co-defendant statement can never be good for you as as the principal. It can never be good because it makes it look like it's the Titanic, the boat is going down, and everybody is jumping off the ship to save themselves. And that's not a good look. Even if he comes back and try to digress, like I said, even if he comes back and say, well, I was just saying that just to take the deal that I took. Well, to your average person, when you think about this, you got to think about similar to your viewers or similar to like it's, you get, I think the mind state of the juror, from the defendant's point of view, the mind state of the juror is underestimated. It's just your common everyday people that watch TV that use the same inference to come from A to B to, jump past C and get to D. So you gotta respect the mind state of the juror, the inference, everything that they avail to. You gotta expect that they listen to, your platform. You gotta expect that they listen to other platforms, that they're putting these things together. So it's not enough when the co-defendant, I think, swears to a statement and then try to get back on the stand and say, yeah, I was just lying. I was just saying that just so I could take the deal. at that point, you talk about veracity of the witness, the believability of the witness. And when you talk about that, if, I believe that when it comes to trials, that if you burn your veracity, if you burn your ability to be perceived to tell the truth, at one point in time, people will always continue to question that, So as it relates to your question specifically with Gunna and how does that affect Thugger's case, I think that it can't be perceived as good.
Yeah,
absolutely.
Yeah. Now, the other thing, like as it relates to his case and his Thugger's case, when you alluded to that, to be honest, it'll be like I would be less than a good attorney if I try to talk on that case without seeing any other facts. Oftentimes, if I, even with my cases, right, I'll get them in, my client will say, "What do you think?" And I'm like, "I haven't received the discovery yet. Let me get the discovery. When I get the discovery, then I'll be able to let you know exactly what I think. Even if I only got like part of the discovery, let me get the rest of the discovery, and then I'll be able to tell you." So if somebody, who's not on that case starts to try to tell you about, perceptions and what they think and his chances and things like that, I think it's a stretch, because without being on that case, without having that file, without having the facts before you, it'll be a stretch and a long guess.
Respect.
Definitely. Now, you talked about the jurors earlier.
No doubt.
You done a lot of trials. You said you done jury trials and judge trials. Obviously, they don't want a jury trial. I mean, I'm smart enough to know that.
Right.
They want, I guess 11 or 12 people rather than one person judging you. What type of people if you could speak on this, is the defense trying to get? Is it going to be from the Atlanta area, Fulton County? What type of people do you think they get?
You know what? That's a great question. That's a great question. And and again, it depends on, and I believe that for the answer to that question changed the more I practiced law, right? Now I would say the type of juror that I would want depends on my theory of the case that I ultimately would have, right? So if you have like a simple case with a simple theory, you would probably want, people that can just accept those facts, common people, or people that will understand your plight. If you had a more complex theory of the case, where you need like kind of thinkers on there to understand the strategy. Like, let's just say, in Young Thug's position, right? He's like, okay, I'm so much of a boss that for me to be at the top of the pyramid, to understand what's going on at the bottom of the pyramid, that would take a lot. I have people that I tell what to do daily. And then based on when I tell them what to do, they kind of, follow order. And then based on that, they run off to task based on what I tell them to do. Right. In that particular case, you would probably want a different type of juror, maybe a manager, you are a manager of lots of people, and those type of people. So I think that the specific type of juror that you want, you're going to want somebody who is empathetic or can kind of vibe, for lack of a better word, with your theory of the case.
Right now, being as though
And
that's
every case has to have a theory. Like every case has to, you got to be able to summarize that theory in, 5 sentences. Thugger did not commit the offense of this because he did not knowingly, know that these people down here were doing these acts, at this time, because he was too busy off in California, wherever else, running his business. Nor should he have known that these street people,
Right. Would you in your opinion, would you say like people like, they say if you saw me and him, we were jurors, would you try to kind of get rid of us, knowing that we're like more from the hip hop genre? You're looking at people like that, what they're wearing, what lifestyle
you know
they come
what?
from. Yeah.
they got a it's called a Batson challenge, right? So let's make sure that's it. I believe that's what it is, where you can't, where you're not supposed to get rid of a juror because of race. So, with that, just to kind of speak on it, they can't. Yeah, they can't get rid of a juror because of, dismiss a juror because of their race. But, sometimes they find other reasons, right? So it's like, if a police officer sees somebody of color or, a person other than white driving and they want to stop them, but they don't have a reason, but they'll say, okay, well, you have a picture of a cross or an angel hanging off your rearview mirror, right? So we're going to stop you for that, saying you were obstructing your vision, but really they just wanted to get to your license and get inside your car to see, if you have any drugs or anything like that on you. So, and that's been used. It's called like a precursor, but if the precursor is valid, then they can still do the stop. Well, the same thing. Oftentimes, I think that people would get rid of more empathetic jurors, and they believe that the let's just say in this particular case, like you alluded to, the hip hop type juror or somebody who look like they might listen to that. They might try another reason to get them off the jury. And I've seen, let's just say a person may have had a criminal charge from, that person may be 45. They may have had a driving on suspended license or a DUI when they was 18, and if they forgot about it, and they got a laundry list of questions that they ask you when you're applying to be a juror. Have you ever had any criminal background? Do you have pending cases? All these things. So you got to answer it. So, when you go to the jury, you put no right there and you get questioned and they say, well, you put no, but didn't you have a DUI back in 1979? Now they could get you off the jury because, you forgot that you had this, this case way back when, and you forgot to put it on the doc. So yeah, it's reasons why they try to, pick empathetic people off. And it's a strategy thing, right?
Right.
But yeah, definitely. I would, like I say, when I first practiced, I would always, try to go for the more familiar juror because they felt easier to talk to.
Got you. We a couple of years ago now, which is crazy to even think about. O and I went out to ARAB's trial. We caught a few days of that. O more so than me. And while we were sitting there, we listened to the defense, we listened to the prosecution, and nowhere close to law experts. I didn't think being in the building that day, those few days, you had to be seeing the substantial amount of evidence the defense had in defense of ARAB and the surprisingly low amount of evidence that the prosecution had on him. It wasn't really sticking. And it also seemed as though the judge that afternoon was very partial to the prosecution and really, really biased toward the defense. And then we see the result and we see the verdict of him doing 40
something. So let me ask you this. Well, I don't know. Was that a jury or was that a bench?
Jury.
It was a jury.
It was a jury trial? Okay. Right. Yeah.
So,
yeah.
So what I want to ask
go ahead. I'm sorry.
No, I'm sorry. What I want to ask is from your position, right? Because we've seen it clearly on one side, but it seemed like the fix was in when we were in there and we seen the result. As a lawyer, as a defense lawyer, if you're sitting in that situation, do you kind of know that, all right, the fix may be in and there may be nothing, no matter what we present, there may be nothing we can do because they want you and they're going to get you. Is it that deep in this?
Well, that's why we, that's why we choose a jury, right? And it's supposed to, quote unquote, be a jury of your peers. But the likelihood that is a jury of your peers is, kind of slim to none because, our peers would be, more African-American and, whatever. But and it's a couple of caveats that goes along with it. To answer your question, yes, sometimes it feels like that we are the only thing. When I say we, I mean the defense attorney is the only thing that's stopping this powerful locomotive train from coming down, on our clients, with our clients behind us, and we're kind of like, stop train, but here comes this train, right? Because it feels like not only, is it difficult, prosecution wise, but the judge is not ruling in your favor, just a lot of different things that's not going your way. But we still, we stand. And that's one of the reasons why we, when you get the jury trial, you let the jury know, my client chose you. He had the choice. And this is what I do. I tell him, my client had the choice. He could have went with a judge, but he wanted you. And at that point, the client got, I think we say at least three choices. Bench or jury to plead guilty or not guilty, and to testify or not. And yeah, so you let them know that you're here because my client wanted you to be here. And yeah, and if the facts are, in your favor, hopefully everything will turn out right. But it's still no guarantee. I've been in juries where, I had clients that were, they couldn't afford certain clothing, and so, behind a desk like this, you couldn't see down further than that. So when my client went up to testify, he had a suit on up top, but at the bottom he had on gym shoes. That's what we call them up here, gym shoes, sneakers. So, but anyway, when he walked across and, the jury saw that, ultimately he got found guilty. And when I went to ask the jurors after, like, what happened? Why did you find him guilty? One of the things was, one lady said, well, he thought he was sneaky. He had on gym shoes in that suit. And I'm like, what did that have anything to do with the testimony of the client? You know what I mean?
Crazy.
But yeah, but that's, jurors like find some of the quirkiest things to, but and that, again, that's when I was a younger attorney. Now I think I'm an optimist, so I believe in people. So I try to speak to people when I do a jury. So, we just kind of go from there.
Right. We won't hold you too much longer. I want to ask you, I was just kind of like, this was kind of, ringing in my head to ask you, is there ever a time where a judge trial is better than a jury trial ever in any particular type of case? Or is it always better?
Okay. So, to me, and, of course, you got a ton of viewers, and some of them may be lawyers, so they may think a little different. But to me, it's an old maxim, right? An old saying where they say, if your case is about the law, you choose a judge. If your case is about like facts, where you want like emotion to ring out and things like that, then you choose a jury. So that's like the initial determiner in application, what I use. Like, is this a legal case? Is this a legal issue? Let's just say when we talked about mens rea, right? That's a legal term. Mens rea means nothing but mind state, right? So a person knowingly makes physical contact with another, right? So, right. But if my case was about where the person tripped and he fell and he bumped into him, well, you know what? He didn't knowingly do it. He didn't have the proper mind state. Explain that to the judge. But if it's more of a factual case, then you're supposed to go with the jury. But it's never really that simple, especially the higher the cases and the more that's at stake, right? So that being said, with the more that's at stake, I generally tend to lean towards jurors because I'm not comfortable with the fate of my client's hands being in one person.
Powerful. Definitely good. Yeah. So tell us a little bit about your practice on the way out. And make sure you give yourself a shout out as well, your website and what you could do for people as well. That'd be dope.
Yes, sir.
No doubt. Thank you. I appreciate it. What I'm venturing into now is personal injury and medical malpractice referrals. So you can find me on Facebook, Instagram at AFW Law. My website is www.afwlawgroup. And again, if you or your family members have been injured, y'all got the car accident, personal injury, you feel like something happened at a hospital or a nursing home or anything like that, give me a call at 844-AFW Laws, just like it sounds, and then we'll get you in the right hands.
Hey, brother, we appreciate you reaching out. We appreciate your expertise, sharing your time. We definitely don't take anybody's time for granted. We definitely appreciate you. And like you said, tap in with the brother if you have any of those needs. And we appreciate your time, man.
For sure. All right, gentlemen, I appreciate y'all. Y'all take care.
Indeed, indeed. Attorney Anthony Williams on the Hip Hop Uncensored podcast. Salute, my brother.
All right, gentlemen. Yep.
All right, brother. We'll be in contact. Appreciate you.
Don't do that. Don't do it.
No, just take him out. Yeah.
We still live. All right. We still good in the building, man. Dope interview, man.
Yeah, definitely, man. Some real good information.
And that's this is why we want to get live and really start getting with you guys. Obviously, this is a special situation. We're talking about Gunna's case, but we'll be on every Friday. We'll be shooting the shit with y'all. We'll be getting y'all engaged. We'll be getting y'all involved. Right. If you got topics that you want to talk about, drop them in our community pages, whether you be watching on the Hip Hop Uncensored podcast, Hip Hop News Uncensored, Viral Hip Hop News. Let us know what you want to talk about. Fridays, we'll bring those up and we'll get you guys engaged and have different ways that we'll make this shit dope for y'all, man. We're about to start getting live again and really getting and touching the people like we used to, man. This is something that we've been wanting to do for a long time, and it's only going to get better from here, man.
Yeah, so every Friday, 5:30 Eastern time. Just be ready. We're going to be here every week, recapping what went on, in the world. We're hip-hop specific, but we talk about all type of different stuff. Y'all should know that. We interview people from all different walks of life. So make sure you tap in with us to get us live. You might, get a treat, catch us live some other time, but guaranteed every Friday, 5:30 Eastern time. And we'll let you know otherwise if we don't go live. But yeah, I just love it, man. I'm glad it's Friday. I'm happy.
Yeah.
And a great show. We never know what next week's going to hold. We'll be talking about. So that's great.
And you never know who'll be here with us, man. You can never expect who's going to be on the podcast with us. So you got to stay tapped in. And we can't wait to give y'all nonstop content like we've been doing for years now. But until next time, my brother, Hip Hop News Uncensored, Sam, and Vile Hip Hop News together, we are the Hip Hop Uncensored podcast. We appreciate each and every one of y'all that tapped in. Keep dropping them area codes, even if you're watching this on the back end. We love y'all, and we're out of here. Peace.